When we think of estate planning, the first document most people think of is a will, or legally known as a last will and testament. Movies and TV have really misguided most of us about the role of wills. A will is a document intended for use by the probate court. Essentially, it directs the probate court on how to transfer property when you pass away. Probate is the legal process of distributing your assets on your death and determining the validity of your will if you have one. The public knowledge of the probate process is often incorrect and vague, perhaps a result of scare tactics. Clients may say, well, my parents or my family was fine without an estate plan, but due in part to the growing complexity of privacy laws and protecting information, the days of those informal arrangements have largely ended. If your will were a car, your successor would not automatically have the keys to access your car when you pass away. They would need to get the keys from the probate court. Without a will, Michigan law governs the distribution of property through a series of default rules. The number of people in blended families who die without a will is alarmingly high. They are the ones who need it most because the default rules of intestate succession won't work well for their family, or more importantly, they don't align with their goals. For example, the surviving spouse receives the vast majority of a probate estate where there is no will, and they might want to protect their children from a previous relationship. A will also appoints a guardian and conservator for any minor children. It does allow whoever you nominate to serve without court supervision and without bond, assuming that there are no disputes. This does make their job easier. So, what's so bad about probate? It's a very paperwork heavy process. It's not the end of the world. However, the probate process is a matter of public record, which many people don't like the idea of others knowing how much stuff they have or who it's going to. It also takes a minimum of 5 months under Michigan law. There are a lot of required fees, including an application fee, an inventory fee based on the value of assets that are going through probate, and a notice to creditors publication fee. Of course, the most expensive fees are the attorney fees, and most probate matters cost several $1,000s. Most importantly, all of this is preventable through pretty straightforward estate planning and usually a revocable living trust. So, a will is important if you would like to avoid a contest about who your children should go to, or you wouldn't want the default rules of who would receive your estate to dictate where your property goes. A will is like an emergency savings account. It's certainly better than nothing, but it's not a full-fledged plan that helps most clients or their families to the extent that they would prefer.